And now to another high-profile trial, a murder trial over the death of Ahmaud Arbery. Lawyers for the three men who have been charged in Arbery's killing have rested their case, but not before one of the defendants, Travis McMichael, who shot and killed Arbery, returned to the witness stand, where he was grilled by prosecutors over his version of the deadly shooting. CNN's Martin Savage, live for us in Brunswick, Georgia. Martin, this may have been the most consequential day of the entire trial. Tell us about it.
Yeah, I think you're absolutely right, Brianna. Good morning to you. You know, the prosecution used 8 days and 23 witnesses to make their case. The defense used just 2 days and 7 witnesses. But as you say, it's the last day of testimony that could make all the difference in this trial.
Closing arguments will begin Monday in the state trial of the three men accused of murdering Ahmaud Arbery outside Brunswick, Georgia. Travis McMichael taking the stand for the second day as the prosecution finished their cross-examination of the man who fatally shot Arbery.
Didn't brandish any weapons?
No, ma'am.
Didn't pull out any guns?
No, ma'am.
Didn't pull out any knife?
No, ma'am.
Never reached for anything, did he?
No.
He just ran.
Yes, he was just running.
Lead prosecutor Linda Donikowski pressing McMichael on why he and his father, Gregory McMichael, would think that Arbery would be trying to get into their truck.
So you're telling this jury that a man who has spent 5 minutes running away from you, you're now thinking is somehow going to want to continue to engage with you, someone with a shotgun, and your father, a man who's just said, stop or I'll blow your head off, by trying to get in their truck?
That's what it shows, yes, ma'am.
McMichael giving this reason when the prosecutor challenged inconsistencies between his testimony and what he told police right after the shooting.
I just killed a man. I had blood on me still. It was the most traumatic event of my life. I was scared to death.
She also asked why McMichael and his father did not initially tell police they were trying to make a citizen's arrest.
During your statement to the police, did you say that you and your father were trying to arrest Mr. Arbery, did you?
In the statement?
Yeah, to the police.
No, ma'am.
All right.
The prosecutor pushing for details of McMichael's self-defense claim.
And you were right there, and you just pulled that trigger immediately.
No, I was struck, and we were face to face and being struck, and that's when I shot. So he came up, I think it was when we were hit. He started striking. He was on me. He had a shirt or, something to that point, and I had the gun. And I was too close to draw on him.
So you're saying that all of that took place. He's got your shirt, he's striking you, you've got the gun up in this thing, and you can't draw down on him, and it's a struggle, and he's on you, and you're going back and forth in front of the truck? Is that what you're saying?
Yes.
The defense calling neighbors to testify about perceived crime in the area.
With that understanding, we rest.
Then resting their case in just 2 days. But before that, defense attorney Kevin Goff, who represents William Roddy Bryan, filing a motion for a mistrial after a state prosecutor asked a witness this.
Do you believe that someone stealing is deserving of death penalty, Mr. Cofer?
Irrelevance, Your Honor.
The judge admonishing the prosecutor, calling the question inflammatory and irrelevant, but denying the mistrial request. And Goff's third motion about people in the public gallery during the trial, specifically calling out civil rights leader Jesse Jackson, who was inside Thursday seated close to Arbery's mother, Wanda Cooper Jones. Meanwhile, outside,
No matter what he say, we gonna pray anyway.
Hundreds of black pastors and members of the community gathered with the Arbery family for a prayer wall.
I did not come in the courtroom to protest, I came to pray.
After the day in court, Cooper Jones saying she wanted to hear Gregory McMichael testify, though he will not. But she's optimistic about how the trial will end.
I want to remind you, it was 74 days that we went without an arrest. Things happen, and now we're here, and I'm very confident that we will get a guilty verdict.
And a reminder, all 3 defendants in this case have been charged exactly the same. The most serious charges they face are malice murder and felony murder, and if convicted, they could all face life in prison. Brianna?
All right, Martin Savage, live for us in Brunswick, Georgia. Thank you.
Joining me now, CNN legal analyst and criminal defense attorney Joey Jackson and criminal defense attorney Stacey Richmond. Joey, always a risk to put the defendant on the stand. Now that we have been through it and seen it all, how would you evaluate that decision?
Listen, hindsight 2020, it's always a game time decision. You evaluate, you see how the case is going. I think that the defense made no headway with respect to the actual people's case, right? In the event that you're a defense attorney, you want to challenge, raise reasonable doubt, challenge the case. I think they didn't do that. And so I think you have to do the Hail Mary. You have to be, they were somewhat desperate about it. Now, what are the imperatives to do that, John? I think there were three. Number one, you want to explain, if you're in the defense, what was going on and what led you to that critical moment. You want to explain why you availed yourself of the citizen's arrest law, right? Crimes in the neighborhood, everything going crazy, heightened alert. So that's why he's the guy. We had to chase him. Number two, I thought was interesting. Remember, the judge denied the use of a expert witness as it relates to use of force. And essentially, they used this witness as an expert witness. He was talking about the use of force continuum. He was talking about escalation, de-escalation. I think the third thing, what they tried to do in a very tricky way, is really imbue him with the authority of law enforcement. Try to paint him as law enforcement. We know people don't like to convict police officers. So if you can give your client the sense that, hey, he's a cop, he really is, he's one of us. The reality is that perhaps that plays favorably. Remember who you're talking to, right? A jury, 11 white, 1 black, perhaps it plays. But on the issue of the cross-examination, devastating. Too many things that he really had to concede. And you don't know that he's grabbing for the barrel of a gun? You didn't tell the police officer that? So what was your justification, sir, for actually using self-defense in the first place? You say he bolted when you said, hey, I'm going to call the police. You didn't mention that. You said that to the jury. You didn't happen to mention that the day of. So too many inconsistencies, too much to explain. I thought ultimately it hurt, but they had to take the risk. I understood the analysis in doing it. It just didn't work to the effect that it should have, could have, and I think that they hoped that it would.
Stacey, the subject of what Joey's talking about, concessions that the prosecution forced out of the defendant there, I sort of saw three. Number one, that he had other options along the way other than to chase him in the truck and ultimately pull the trigger. Number two, never brought up the idea of a citizen's arrest. He had to admit he never brought that up at the time. And number three, exposing the discrepancies between what he told police and what was testifying on the stand. What's the most important thing, do you think, she got out of that?
I think what they got as a whole is they completely deconstructed the concept of self-defense. It demonstrated that they were the initial aggressors, and they did nothing to step back to say, hey, he is now the aggressor on me. They held the line. The prosecution held the line and took that away from the defense. So I think this is extremely problematic for the defense.
Any points scored by the defense? Did they get anything out of this? If you're the defense lawyers, what are you hoping the jury saw in all this?
The goal here was that the jury saw that he was afraid in the moment and he reacted in self-defense in that moment. But in New York, the jury instructions are very clear on what you must consider. And one of those things is if you are the initial aggressor, you do not have the right to self-defense. But if you are the initial aggressor and then the person that you are assailing comes upon you, then you may still avail yourself of self-defense. The question is, did they turn that tide?
Joe, we got about 30 seconds left. Chances that the jury looks at the three defendants differently?
I think that's always certainly could be the case where they look and they evaluate, but birds of a feather, right, flock together. And the reality is that all of them have and are looked at as these people who should not have engaged in what they did in looking and detaining and finding him very quickly, John. I don't even think they should get an instruction, the jury is, on citizen's arrest law. If you looked at the defense that they made, they were talking about there was a burglary this day, that day, the other day, three weeks hence. Look, the reality is what was the crime committed at the time?
And
that's what the law says, nothing more.
And there was nothing to connect Mr. Arbery to those crimes, and they ultimately admitted that.
Well, they didn't get it. If they don't get an instruction on citizen's arrest, that would be devastating for the defense. Joey Stacey, thank you.